Ann Badmus, and welcome to our webinar entitled Trump Won, What It Means for Immigration. I think we still have some people coming in, so please do join in. And we're going to get started right now because I have a lot to cover, and it looks like we are going to have some questions. So I want to be able to give time, as much time as possible within this hour for any questions that people may have. So just to be sure that our technology is working, could someone just put into the chat whether or not you can hear me? I'm assuming so, hopefully. So just put yes. Thank you so much. I already got some yeses there. Thank you so much for that. All right, so some preliminary information to go over just regarding our webinar itself. This is a great forum for you to be able to ask questions at any time. And to do that, what you want to do is to use the icon or the Q&A icon that should be somewhere on your screen, whether you're on a phone, iPad, tablet, or desktop computer. You should see an icon that looks like a question mark. So you want to use that to type in your questions. This will help us to keep track of the questions so we can hopefully be able to answer all of them in an orderly fashion. So if you have questions, please move them over into, or please put them into the Q&A panel rather than the chat feature. The chat feature is for you to be able to let us know if there's an issue of hearing or technology or something like that. But if you want to ask a question, put it into the Q&A. And then regarding your question, be sure that we are in a public forum, so there are people who can view these questions or hear these questions, and we want to be sure that you keep your question confidential to your matter. So please do not provide personal details in your question. Just ask them in a general manner. So just a little bit for those of you who might not be familiar with our firm, just wanted to let you know that we are Badmus Associates. My name is Ann Badmus, and my firm and I have been helping thousands of clients with immigration matters since 1993, and we've been fortunate to receive some recognition for the work that we do in various venues, or various platforms, such as best law firms in the Dallas area by U.S. News and Report, as well as the Dallas best lawyers list as well. So let's go on to the last housekeeping matter. Just know that this presentation is really for informational purposes. We are not able to provide individual legal advice because that is, of course, a very specific or that is very unique to each person. So please do not rely upon any of this information to act, or if you rely on it to the point of you will further seek out immigration attorney to help you adapt that information or use that information for your individual matter. With that said, let's go on to the content of our presentation. Now, this is very much a sort of an overview. We are, and really just kind of our thoughts on what could happen based on the information that we've received from the Trump campaign, as well, which is the Agenda 47, as well as the Project 2025, which, although the campaign disavowed it, it does have quite a few of the same, or the Agenda 47, which is the Trump campaign's agenda, or their policy agenda, does adopt quite a bit of what we see in Project 2025. This is also sort of our thoughts based on the previous Trump administration back from 2017 to 2020, which saw, for immigration at least, well, not just immigration, but basically we saw the Buy American, Hire American policy, which very much applied to immigration and how legal immigration and how it was processed. So there are significant differences between the Biden administration and the Trump administration with respect to those policies, and a lot of policies that were under the Trump administration were removed or no longer used by the Biden administration, but we anticipate that with the new Trump administration, we will see some of those same policies being reinstated. So we don't have the time to cover everything. I am focusing on certain aspects based on our past experience and based on the practice area that we work in, which is primarily employment and family immigration. So I really won't talk about mass deportation and things like that. I'm really trying to give our perspective and we don't have a crystal ball, but based on what we saw in the past and what we see from the policy documents that we have been able to get a hold of, what we think might happen. But of course, we will not know until after January 20th what specifically will happen. So next, I just want to kind of give an overview. And this probably is basic for most people, but just to explain our U.S. government system. So we have 3 co-equal branches of government. And so that includes the executive branch, which is the president and president's branch, I guess, are governed by the president. Then we have the judicial branch, which is governed by the federal court system, with the Supreme Court at the top. And then we have legislative, which is Congress, consisting of the House of Representatives and the Senate. So Congress is responsible for passing laws. That includes immigration law. So things like whether someone can qualify for a green card through a specific route that Congress has made or has designated can only be changed by Congress. So only Congress can eliminate categories of immigration. So for example, Congress can eliminate whether a family member can immigrate through U.S. citizen sponsorship, but the executive branch cannot do that. The executive branch, the president's powers are limited to interpreting and executing on the laws passed by Congress. Now, of course, the executive branch can set policy and work with Congress to implement the policies that the executive branch believes should be in place. So there can be a lot of influence, and there probably will be a lot of influence by the Trump administration on the Republican-led Congress. So there may be congressional changes that happen, but I'm not really going to be able to predict that. That's going to be a process that certainly will take some time, but we may see some legislation that will change the way immigration is considered, or is not administered, but it's done. We haven't had any real comprehensive immigration changes since 1965. So those of us who have been doing immigration for a long time have always advocated that there needs to be changes. But we will see what will happen under this administration, because unfortunately there's not really been any significant changes under all the administrations since 1965. So let's just go on to, as I mentioned, the areas that we practice in and what we think might be considered. And I do see already a lot of questions, so we will go through this as quickly as possible so that we have plenty of time to answer those questions. And some of those questions hopefully will be answered by our presentation today. So what I want to talk about today is the impact on work-based immigration or employment immigration, which is primarily our practice. Badmus Associates mainly focuses on work-based immigration. And so we work with clients who have temporary work visas, business visas, as well as permanent residence green card applications based on employment, business, or work. So what we saw under the past administration of the Buy American, Hire American policy, which again, we believe was going to come back, there was a lot of focus on H-1B visas and attempts to change the H-1B visa system. And actually, there was quite a bit of impact on existing or people who are already workers who are already in H-1B visa and getting and whether or not they got extensions. So what we see with that, we don't really have time again to go into all the details, but it's anticipated that the new administration might attempt to eliminate the lottery system and instead create a merit-based system that will now prioritize highly skilled immigrants. So what do we mean by highly skilled immigrants? Generally, based on the proposed policy we saw before, we were talking about master's degree or higher. People who are higher level, so those who may be graduating, foreign students that graduate from universities and have F1 visas and then transition or try to transition into H1B visas may not be able to as much under the new administration if they go to a highly skilled immigrants or highly skilled system for H1Bs, where they're only wanting to consider those who have at least master's degrees or a certain amount of experience in order to qualify. And how they could do that would be what they attempted to do in the past was not successful, but we don't know, it could be successful this time, was to restructure the prevailing wages system. So with H1B visas, there's always a requirement for the Department of Labor to provide prevailing wage or surveys that show what would be the minimum salary that should be paid to an H-1B applicant. The law is that an H-1B employee must be paid the higher of the prevailing wage, which is the wage in the local area, the general wage considered for that occupation in the local area, or the actual wage, which is the wage that the employer typically pays similarly qualified employees. With restructuring of prevailing wage, right now we have 4 levels, starting with an entry level to the most highly skilled levels, so levels 1 through 4, that the Department of Labor determines based on experience and the degree, whether or not what the minimum prevailing wage should be. If the administration does what it does, tries to do what it tried to do in the past, which was basically move those wages up very high so that entry-level people would never be able to receive or be eligible for that higher level wage, because employers just are not going to pay those higher level wages to people who are entry level. So that's just kind of briefly, again, it's going to be a complicated system, but that's kind of what our thoughts are in terms of the impact that we would see some kind of restructuring of prevailing wages. We also we did see in the past, and we'll probably see again, a redefinition and a limitation to what is considered a specialty occupation. So under H-1B, for H-1B visas, it is required that the position be a specialty occupation, which can change, which basically the government determines based on its understanding of the type of degree and how specific the occupation is. So, for example, a lot of IT professionals under the Trump administration were no longer considered specialty occupations because they did not believe that it met the definition. And again, that was the subject to interpretation by the officers, subject to the policy. So we may see that fewer degree professionals, such as people who are maybe more in management or IT, as I mentioned, or something outside of being an engineer, which will, by law, is considered a specialty occupation, and there's not much interpretation for that. Or a physician, by law, is also considered a specialty. A lawyer is considered a specialty. A teacher is considered a specialty, and an architect. So those are the 5 kind of protected occupations under congressional law that is found to be a specialty occupation. Everything else is subject to interpretation by the administration. So we may see limiting interpretations of what is a specialty occupation. We can also see denials of H-1B renewals because of that redefinition of specialty occupation. So whereas someone may have had, and I'll go back again to an IT professional as a software analyst or systems analyst, may have been considered a specialty occupation, had received an H-1B. If your renewal is coming up under the Trump administration, they may decide and determine that it is no longer considered a specialty occupation based on their own definition of that, and may deny the renewals, which we did see happen quite a bit in the previous administration. So that's about all I can talk right now about H-1Bs, because we have, do you want to get onto some of the other other types of visas that might be affected? and related to that is the H-4 EAD. So H-4 EAD is a rule, of course, implemented by. It's not a congressional rule, so it's not a congressional law. That's so this is subject to interpretation or subject to change by an administration. So H-4 EADs was first implemented under the Obama administration. Trump administration had tried to eliminate H-4 EADs. There had been some lawsuits about that, but they're under our understanding of Agenda 47 and Project 2025 that there's still going to be a push to eliminate H-4 EADs for spouses of H-1B workers. So that's something we're going to be on the lookout for. Also, with similar to work authorization for students, F1 students, there may be a limitation of OPT so that there would be either less time or less eligibility, and it might be even limiting OPT to only STEM graduates. Again, these are possible things. We don't know if it's going to happen, but there has been some indication through the policies that have been put out there through the campaigns of this being a possibility as well. Next, we'll just talk briefly about some of the other visas, work visas that could be affected, and not necessarily changing, well, not changing the law itself as to what the criteria is, but we could see increased requirements for evidence that we did not see before. The government, the administration can change evidentiary requirements, saying that no longer will we accept ABC. We will now need to see more evidence to prove your case. We did see in the past under the Trump administration, previous Trump administration, higher denial rates of applications where there is a lot more discretion on the part of the administration or the officers to decide a case. So for example, on an O1 extraordinary ability visa, which the criteria is very much subject to interpretation. It is very much subject to change depending on the individual officers and depending upon the attitude of the administration itself. L1B transferee visas may also be considered. These are visas that are based on companies wanting to move employees from a foreign country into the U.S. based on their special knowledge or special skills. And with the Buy American, Hire American policy, there may be more scrutiny as to why can't an American citizen handle or do that job? Why do you need to bring someone over from another country, even if they were working for your company overseas? Maybe you should be looking at U.S. workers to handle that job. So you can have that Buy American, Hire American policy be considered under or be a big part of these types of visas, including the TN visas as well. The other part of that I think may also give pause to us is lack of deference to previous approvals. So what I mean by that is currently under the Biden administration, the policy is that if the government has approved a previous application, such as a O1 visa in the past for someone, if they apply for a renewal, they should be, they should not have to reprove everything. They should be given some deference to what happened in the previous approvals. Under the Trump administration previously, they took away that policy or did not have that policy, even though it was previous policies before. Previous administrations did have that policy. They said there was no deference to that. We can decide applications as if they were brand new and that there was nothing, that was not approved previously. So those are the kind of things that can make it a lot more unpredictable for these applications. Now, that's not impossible. So I don't want people to feel like, oh, there's no way things are just going to be so bad and we won't be able to prove our cases and things. But we will need to be very, very, as always, careful about our applications and providing a lot of evidence to support it. So we may see our applications being twice as big or twice as thick as we have currently. So let me go on to green cards, because I know I see some questions on green cards. So what do we expect to happen with green card applications? Pretty much with EB1A, which is a extraordinary ability visa similar to O1 or extraordinary ability green card process. Similar to the O1, there's a subject, those visas or this green card is subject to a lot of interpretation. So if the Buy American, Hire American policy is put into place where the administration is again wanting to look at it from the viewpoint as why can't American citizens do this job or provide the services or be the professionals that we look to rather than someone applying who is not in the U.S. applying for this status. They might have very more strict evidence requirements. We did see higher denial rates under the previous Trump administration, and we definitely saw more RFEs, requests for evidence. So we expect that with EB-1A. We also expect that with EB-2 national interest waiver. Again, another very discretionary type of green card process. So whenever you have those types of processes where there is a lot of discretion, again, we are expecting to see more evidence being required, potentially higher denial rates, and more requests for evidence. For EB-2 and EB-3 perm applications, we also expect increases of audits of perm applications where we have to prove our case, prove that we dotted our I's and crossed our T's and did all the recruitment appropriately. I mean, that's always the case, but usually the audit rate is fairly low, but we do anticipate more audits under the new administration, which could lead to longer processing times. And in addition to that, similar to H-1B, there may be higher wage requirements if they restructure the prevailing wage process as well. And so just so we can get to the questions, I just have a couple of more, just some tips for immigration applicants. Definitely, this would not be a time to do it yourself if you consider to do that, or get help from, if you are looking for help, make sure you're working with experienced immigration attorneys who have the experience not only with this administration, but preferably with the previous administration as well, the previous Trump administration, because they hopefully will be able to help you navigate a little better. Make sure you apply early for extensions, any deadlines. Make sure that you are submitting those if you have particular timelines for your personal situation where you need to get things done in a certain manner. You want to apply as early as possible because we do expect longer processing times for nearly every type of application. And then also make sure you're preparing thoroughly. And, sometimes it may be difficult or hard or just really inconvenient to try to get a lot of information, but you really will have to get that information. And then finally, I'll just go over a few things with respect to legal immigration that we expect. Again, as I mentioned before, no deference to previous decisions. And this will happen not only with USCIS or Department of Homeland Security applications, but if you are processing at the embassy to get a visa stamp, again, they're not required to give any deference to the fact that you previously had a visa, like for example, if you had an H-1B, well, not H-1B, but an O-1 or some other type of visitor visa or things like that, they no longer need to give any deference for that. We also are a little concerned that could be denials. I think towards the end of the Trump administration, there was a previous Trump administration, there was a policy of saying you don't necessarily have to give the opportunity for an applicant to correct or provide additional information. If that information is not there, absolutely not there, we can deny without a request for evidence. So we need to be sure that we have everything in place, even if it takes longer to prepare and submit the application. We need to be sure that we have everything in place because we may not have the opportunity to provide information later. And again, we can also expect more inefficient processing, leading to longer processing. Under the current administration, we have seen lots of improvement, not that it's been super quick, but we have seen lots of improvement in processing of various applications on average. Based on my experience, it's definitely been faster in most cases than under the previous Trump administration. but we may see, for example, if for green card applications or adjustment of status applications, the expectation, or currently we are seeing applications approved without interview. Under the previous Trump administration, interviews were required all the time. And so if that's brought back, then of course it's going to cause delays as well. So there could be other processes that will, in other applications, that will prolong the processing of applications. Then finally, just a few things about certain programs that are out there, legal immigration programs. So we do expect either plans to end or severely limit deferred action, DACA programs, TPS, temporary protected status, and refugee programs, meaning refugees, people coming from outside the country based on war, political persecution, those types of things. Under the previous Trump administration, there was a severe reduction in refugee programs. And so we expect that reduction to happen again from what we see now. Also, there is the claim of ending birthright citizenship for children born in the U.S. to non-citizen parents. Now, this is going to be pretty difficult for an administration to do, or at least we think it would be difficult because we believe it's a constitutional issue of whether or not someone born in the U.S. is born a citizen regardless of the status of their parents. But this is something that has been brought to the forefront as far as the potential the Trump administration wanting to end birthright citizenship. If they do try to make that an executive order, I'm sure there will be lawsuits, and it will have to go through the federal courts. But we're not certain whether or not the Supreme Court will uphold birthright citizenship, because they could certainly decide in their own interpretation that the Constitution does not apply or does not apply to in this circumstance. Now, when I say non-citizen parents, I don't think that the idea is that it's going to apply to those who are permanent residents. So if you're a permanent resident and you have a child in the U.S., that should not be affected, or at least I don't think so. However, the way that it could apply to those who are here on temporary visas. So if you're here on a visitor visa, an H-1B, an O-1, anything that is short of permanent residence or citizenship, then your children born here under the proposal might not be born citizens of the U.S. Another legislative policy that might come about through the Trump administration's mandate for leadership, they believe that chain migration is a problem. So chain migration meaning under those terms that people are now able, U.S. citizens and permanent residents are able to apply for spouses, children, parents, and siblings. Under the idea of reducing chain migration, there is a push to eliminate certain categories. So, for example, eliminating parents being able to immigrate, eliminating siblings being able to immigrate. Now, this is not something the administration can do on its own. It will have to go through Congress for that to happen, because this is written into the law. But if you have a Congress that is pretty much controlled by the Trump administration, this may be an actual law that would pass in terms of eliminating certain family categories of being able to immigrate to the U.S. And then finally, the travel bans for certain countries. That is a promise as well, particularly those coming from majority Muslim countries, that there may be some travel bans implemented as well. So now I'll go to questions, because there's a lot here. And so I want to leave at least 30 minutes for questions here. Again, I want to remind everyone to put your questions in the Q&A section. I am not going to be in the chat area to answer questions. So if you have a question, please move it over into the Q&A section. That's the only way that I can order, because I have a lot of questions here. So let's start with the first question. that I see here. It's a question about, could we go over what it means for F1 students? So I think I touched a little bit on that in the presentation. So for F1 students, there could be a limitation on OPT, depending on your major or your type of degree that you have. There also can be reductions in the number of these F1 visas being issued. We did see, and in my conversations with some universities, they saw quite a bit of decline in F1 visas being issued at the embassies. And even F1 changes, people changing their status from visitor to F1, we saw a reduction in the approvals of those. So we could see quite a bit of reduction in the number of F1 visas being approved. So we may see a reduction in students, foreign students being able to come to the US. That's all I can really address there because we have a lot of questions. So it's kind of a general question, but hopefully that gives you some idea. But again, this is all based on what we saw in the past. We have no idea about the future, but this could be something to think about. The other question is, what does it mean for J1 scholars intending to apply for J1 waivers? That depends on a lot of things. I mean, right now, as I said, the law is the law as far as who can apply for a waiver. If you're a physician, you go through the process, probably would not have much of an impact on J1 waivers. If it's a discretionary waiver, like a hardship waiver or a persecution waiver, you may see a reduction in those. If it's a no objection waiver, that also could be a reduction. It is totally up to the Department of State to determine whether or not it wants to approve a waiver. So they do not have to approve a no objection waiver or any waiver at all. Like I said, I don't anticipate any like physician J1 waivers to not be approved based on just the Buy American, Hire American policy. But any other waivers where there is a lot of discretion, it could happen. There could be reduction in waiver approvals. Okay. So someone asked about, will a recording be shared? Yes, there is a recording, so everyone will receive a recording immediately after the seminar or after the webinar. Another question is, if you've been working and currently out of a job, can you still apply for EB2 NIW? That's really a question. It's very specific to the individual. Sometimes you can, sometimes you can't. So I would recommend that you reach out for a consultation to talk about your specific situation of whether, first of all, whether you qualify for an EB2 and whether your current visa status and not working or not being currently out of a job, whether or not that would impact the application. Another question is, will green card holders be deported? I don't think so on a mass scale. Green card holders can always be deported, but it depends on the individual situation. If you commit a serious crime, you can be deported as a green card holder. If you remain, so that generally is the way most people would get deported. Or if you stay out of the country too long, you might be refused you might also be your green card might go under a revocation process. But no, I do not think that on a mass scale we'll just say green card holders will be deported, because you are permanent residents, you are legally in the United States. So that I don't think that will happen. Another question is, if R1 is approved, do you need to go back to your home country as a way to get stamped or as a way to get done here? That again depends on your circumstances and whether you've maintained your status. If you have not maintained your current status, then you may not, for any visa application or temporary visa application, if you not maintain your current status, and if you're in violation of your current status, you may be required to leave the country in order to get a visa stamp before you can activate your R1 approval. And there's always a chance that you could be refused, whether it's under Biden administration or Trump administration, any administration, there's always a chance of being refused a visa. But again, it depends on each individual circumstance. Would the green card, the next question is, would green card issuance be also on merit based? Well, that right now, right now it should not be, because green card process, or how you qualify for a green card, is already written into the law. So unless Congress makes that change, it's not going to happen just because of the Trump administration changing it to merit-based. So we're still looking at either, whether you're applying through family or whether you're applying through work, the rules are the rules as they are. So that's not changed yet. It could be. Congress could make changes to those and decide that we're only going to have green cards issued on certain categories or certain criteria. That would probably take at least a couple of years. I can't say at least a couple of years. It just depends on how quickly Congress will move and how coordinated their efforts are to do that. Let's see. I'm going to, if you've already asked a question, I'm going to have to come back to you and just try to, because I want to cover people who have not asked a question. So, question is, so engineers are not specialists? No, that I did not say engineers were not special. Engineers are specialists under the H-1B specialty occupation rules. Also, what can we expect with EB-5 applications? I assume they're going to continue. They're pretty slow as it is, but I believe that they'll still continue. I don't see any anticipated changes in the EB-5 program. There was recent laws enacted about 2 years ago, and I don't think Congress is wanting to take that up again. And as far as what the Trump administration can do, I think they would continue with that, or at least continue processing the same way. Maybe some delays are taking a longer time to process, but I don't anticipate much change with that. For people whose visas have long expired or overstayed, what are the asylum chances? No, I don't handle asylum, so I won't be able to answer that question. Except to say that asylum is based on individual circumstances. So it really depends on what you can prove and whether you can prove that you would suffer persecution or have suffered persecution because of religion, political beliefs, what are the specific requirements of asylum. Can H-1B application for extension start now if the current 3 years is expiring by September 2025? So that's a good question. Yes, it is possible to do that. It is possible to start now. Generally, most people start 6 months in advance, but there is a way to do that if you wanted to apply before the expiration. Another question is, what about revoking existing green cards and denaturalization? So that is a process that has been around. The government and most administrations have not focused on trying to find ways to revoke existing green cards or denaturalize. However, it is our understanding that and we did see a little bit of that in the previous Trump administration, and it's our understanding that in the upcoming Trump administration, that is going to be a focus, at least with denaturalization, which could also, by nature, also end up revoking green cards as well. But that is a very specific process. It's not at least right now, it's not a process where you say, hey, I just want to revoke, I want to denaturalize. There has to be specific reasons, case by case, to denaturalize someone or to revoke their green card. Let's see. Another question is, any effect on EB-2 green card approvals country-based? That's hard to say. The only thing I would say that might have an effect, whether it's EB-2 or any other EB category, there is a note in in Project 2025 that potentially they can stop processing on green card applications where they believe that there's a big backlog and they want to address that backlog rather than accepting new applications. That's not how it works now. If there's an eligibility, you can process or apply for adjustment of status. But under a potential proposal is that instead of moving things along and accepting new applications, there may be a stop on that or a pause on accepting applications. Don't know if that's going to happen. Again, all of this is just potential. Nothing has happened at this point. Another question is, what about U.S. citizens in removal proceedings who appear in court? I don't handle removal proceedings. I really aren't able to address that. You probably better to speak with a removal attorney who understands that court process better than I do. Would it be reasonable, excuse me, would it be reasonable to apply for my mother's green card now before the new administration takes over? She is in Barbados. Well, I mean, if she's eligible, if you're eligible, there's no reason not to apply. I also would say it's no reason to, I mean, you should apply now or later, as long as the benefit is there, as long as there is the eligibility for a parent of a U.S. citizen to apply. So I would say if you're eligible, apply as soon as you can. That would be my best advice at this point. Let's see, if I switch my F1 to marriage, am I able to stay in the U.S. without the process? Generally, I'm not advising you specifically. I cannot do that, but I will say generally, if someone applies for adjustment of status through a marriage petition, then they are allowed to remain in the U.S. While that application is in process. Next question is, for already approved EB-1A petitions, do you foresee stricter consular process for the actual green card visas to the point of major rejections? It's certainly possible. If the consular, right now the consular process is not a great process to begin with, but if the attitude of the or if the administration projects an attitude to its consulates that we're going to be stricter, yes, it could be stricter. If we're going to be investigating longer, we're going to take longer. They may just put applications on hold, which is also frustrating the process because, as the saying goes, justice delayed is justice denied. So basically, we could see that happen, whether it's EB-1 or any other application. But generally, if an EB-1A application is approved by the USCIS in the United States, the consulate is not supposed to redecide an application just because they want to. But they could potentially look at an application and say, hey, we don't think this information is correct. We think there's misrepresentation. I'm not saying there is, but they could look at those applications a little more closely and decide to send back the applications for further review. So again, depending on the directives from the administration and how hardline and how much they want to restrict legal immigration, it could happen. Is there any possibility for an administration to revoke previously approved EB-2 while still waiting for priority date? Yes, I mean, that's always, regardless of administration, it's always possible for an application, an approved application to be revoked. So it is certainly possible. It's even possible for a green card approval to be revoked. So yes, that's always possible. I don't know. I can't say that that's going to happen or that we're going to see a mass scale revocation of a previously approved applications. But generally, to answer your question, it's always possible under any administration. Do you foresee any change on the DV program or green card lottery? there could be, if Congress decides to eliminate the program, and there could be a push for that. I don't know of any particular legislation in place to do that, but that would be what would need to take place. Congress would have to remove that, not just the Trump administration. Let's see. Okay, I think I have 5 more questions here, so we still have a little time. If you have more questions, go ahead and put them in. I'll go ahead with the questions I see now. Let's see, the question is, if you've already submitted an application to the USCIS this year, how is it affected by the new administration? So it depends. If your application is still in process after the new administration goes into effect, there can be changes. It can take longer. The review based on whatever policy is issued at that time can be different. So just because you had applied under the Biden administration doesn't mean Biden rules will be applied after January 20th. Things can change, so that yes, your application, if it's still pending after January 20th, when the new administration comes in, it could be affected in some way. I don't know how it would be specifically, but it could be. What happens if you put in an application using premium process and you've not heard from them since 90 days? Do you withdraw, or what do you do? So that would be unusual. Most premium processing applications are either going to be 15 days, 30 days, or 45 days, depending on the type of application. If you haven't heard in 90 days, then you typically would, first of all, they would have to return your premium processing fee, since they did not process within the guaranteed time frame. I cannot tell you whether to withdraw the application because I don't have specifics to do specifics on your application. What about changes to marriage-based green cards? Married to a citizen, but currently not permanent residence. Currently, application is in process. So as far as I know, there's no changes currently there's no changes. Even if your application is in process after the Trump administration takes office, we would have to see what they would do as far as administering those applications. There, as I mentioned, Congress decides whether someone is whether there is a path to permanent residence, or what kind of path you can take to getting a green card. So marriage to a U.S. citizen has always been a path that's out there. I don't think that's going to change. I don't think Congress is going to eliminate that kind of path to green card. But as far as the administration is concerned, you might see, whereas now a lot of marriage-based applicants are getting approved without an interview, you might not be that lucky under the Trump administration. There may be always a interview required. So if that's the case, then it may take longer to get your green card approved. But it doesn't mean it would not be approved. You just have to attend the interview and prove your case as usual. Do you handle other cases than work-based or family immigration? No, generally we handle those cases. We do not handle removal or asylum cases. We do work sometimes with TPS cases and DACA cases, but other than that, we are working primarily on work-based employment and family immigration. Thank you for asking. For countries that were banned during the last administration, was legal or chain immigration process? So I think if your question is that if you were from, if the applicant was from one of the banned countries, were their applications processed, whether it's family immigration or employment? To a point, so they would be, some of them were processed. The processing in the U.S. could take place. So, for example, if you were applying for a family member, you file an I-130 petition, that would have been processed. Now, but if they were outside the U.S. and they were supposed to go to the U.S. Embassy, if there was a ban that applied to them, then yes, it could, they could have been, they were not processed until that ban was lifted. So it's hard to talk about. There's so many different rules that were coming up about then. So we will just have to see what happens this time if there is a ban, how specific it is, what categories it applies to. It just, we go by a little bit by past experience just to kind of get an idea, but we don't have, we don't know specifically how and what will be done under the new administration. And we won't know until it happens. And then we'll have to interpret it and determine, for each individual, how it would apply to to their case. 2 more questions. We have, would EB2, I see one more, would EB2 process improve or become merit-based? So I think that was a similar question that there is, actually, I really can't say that I know, because again, that's going to be a situation where Congress would have to change the law or change the qualifications for EB2. I don't know of anything yet in Congress that would make us think that it's going to change, but it could happen. It would just be up to Congress whether or not they're going to implement or pass a law to make that change. Best recommendation to file for PERM or NIW early before the new administration takes place. I think even if you're filing now, it's not going to do anything in terms of making any change in the administration of your case. Filing now will get it reseated, but there's no way the Biden administration is going to make any approvals or decisions on those type of applications before January 20th. So your case is still going to proceed under the Trump administration if you file today, for example. It's just not going to do anything in terms of if you're looking at, whether you're going to have a better process. It's just a little too late for that at this point. How would the Trump administration impact on general visa applications or changes in status for specifically Africans or anyone coming from African countries? Honestly, I don't know if I can even say, because I don't know for sure, but I will say that it's generally, processes tend to be longer and harder for African countries, just based on my experience. I don't have any data to support that, but based on my experience, I do see a lot more denials coming out of those countries. But hopefully it will not be any worse than it is now, but it could be. In the event that I would like to apply for a student visa, is there someone in the firm? Yes, we do work with student visas. So you can reach out to us. I would suggest to contact us through our website at badmuslaw.com and fill out the contact form, and that will get the information to us so that we can start working with you. Thank you. And the last question I see here is, if an H-1B visa for extension is done now, can the same applicant also file for the green card application? Well, there's no timeline or restriction for someone to apply for an H-1B and a green card. If you apply for an extension H-1B, that's one process. A green card is a totally separate process, and they don't really affect the other in most cases. So if you feel like you're qualified for the green card process, you can apply for the green card process regardless of what's going on with your H-1B application. Question, will process program that nurses utilize to migrate to USA be okay? That's a good question. I mean, any process, that nurse program, which you're talking about, is actually a PERM, P-E-R-M, labor certification process that hasn't changed in years. If it's going to change, it would have to be done by Congress as well. So Congress could change it, or it could also, well, let me take that back. It could be that the administration could either change the process in terms of maybe making it more restrictive or making it easier. I don't know. It could be either way. And then that process can be changed by the administration. Hopefully they will leave it alone or make it better. But there are ways that they could make it longer than what it is now. Okay. I think all of the questions in the Q&A section have been answered. Again, as I said, if you have a question, if you put it in the chat, we will not be able to answer it. So you need to put your question into the Q&A section, cut and paste it, find your bubble question mark and put it over there. While I'm waiting to see if we have any more questions moved over to that section, let me just again reiterate that the answers, questions and answers, as well as the information that I'm providing here is just that, it's just information. So for your specific case, definitely reach out to an experienced attorney, and we are certainly happy to help you in your work-based or family-based application. I do see one more question in the Q&A. Again, this is a very specific question. I'm hesitant to answer with because this is a public forum, so try not to put your specific information there. If you have a question that is about your particular case, you need to schedule a consultation with us so that we can take the time to address all of the background and information that we need to give you solid legal advice. So to do that, feel free to reach out to us at badmuslaw.com, fill out the contact form, and we'll be happy to consult with you. Another question is, will there be interviews for EB2 NIW? So there's not a, yes, there could be. I will say that under the previous Trump administration, all green card applicants, whether they were applying based on family or any category of employment, if you were in the United States and applying for that through the adjustment of status process, then there was an interview. It was required for all applicants. Right now, it's not. Under law, it is required. Anyway, under the congressional law, it is required. However, it has been the policy and procedure of most administrations to waive the need for an interview for employment-based applicants. But under the previous Trump administration, they required all applicants. So we saw where for many years I'd practiced and hardly ever saw an interview for an employment-based applicant. Under the Trump administration, every applicant was required to go to interview. So of course that prolonged the process, not only for those employment-based applicants, but also for family-based, because now the offices were flooded with having to do interviews for everybody, which slows down the process for everybody. So it is possible, but again, I don't know if it will happen. It says master's degree may not be affected due to high skill. Does that apply to physicians and nurses too? Well, physicians in particular are considered master's degree or higher. So that should not be affected as far as H-1Bs are concerned. Nurses are generally not under H-1B visas, are not considered H-1B qualified. They have other processes that they can go through as well. So this is all could be pretty much. How easy or difficult will it be to get an EB1 approved? All I can say is that under regular processing, almost all of our applications are premium processing. We generally do not do regular processing. We haven't done, well, we do it if the client wishes, but we haven't done that in many, many years. Even under the Trump administration, we use premium processing. Under this administration, we use premium processing and have a fairly high success rate with that. But regardless of processing, I think based on the statistics that we do know overall, not just with our firm, but overall, we do expect that there would be probably a higher denial rate under the Trump administration based on previous experience. Next question is, I'm sorry, Can there, and I'll just take the last two. I won't be able to take any more because we're out of time. Can there be priority process for family adjustment applications? Unfortunately, no, there is none at this point. And I very much doubt it will happen under the Trump administration. I have an L-1B visa in December. Will it be impacted since renewal in December? Will it be impacted under Trump administration? It depends on whether it's still in process after January 20th. If it's still in process after January 20th, then yes. If you do premium processing with the 15-day guarantee, then it will be under the Biden administration if you're filing in December. But anything that's in process after January 20th will be under the Trump administration. Okay, well, thank you all very much for attending our webinar. Hopefully this was informative. I know it's a lot of it is just, we don't have a crystal ball, but we're just trying to give you some idea. I would say to definitely keep tuning in. We are watching things closely and wanting to make sure that our clients and those interested are aware of the various changes that occur all the time in immigration law. So keep tuned in. We will be sending out webinar notices. We also have a YouTube channel that we're updating information as well as our website. So please do follow us and contact us if you have specific questions about your case that we can help. Thank you so much and have a great day.